can be able to.
Okay, we're good to go.
If we could just maybe give a minute. I see people are just coming in. We've got about 110 now. Just 1 minute for everybody to come through, then we can start.
Oh, yeah.
Chair, good morning. We've got about 210 people now. I think we can start. They're still coming through. For the benefit of those that are here already, if we could start, I'm going to hand everything over to you. Thank you so much.
Okay, good morning. Thank you very much, facilitator. I see we now have 231, which is great. Good morning, everyone. My name is Pensi Tlakula. I am the chairperson of the Information Regulator. I am on this webinar with my colleagues who will introduce themselves. There are two members of the regulator, Professor Sizwe Snail Kamtuze and Ms. Alison Tilly. And we are accompanied by senior management. In the interest of time, maybe I should do that. It's proper that I introduce them. We have Mr. Mukelani Dimba, who is the executive responsible for education and communication. Brand new started with the regulator on the 1st of July. We have Mr. Nemasisi, who is the executive of PAIA. And then we have Ms. Vasha Swilal, the executive responsible for legal policy research and information analysis. And of course, there is also Mr. Makubela, who is the senior manager for POPIA. And we have our communications manager, Ms. Nomzamo Zondi. And with those few words, I would like to welcome all of you, and also thank you for making time to attend this webinar. It's been a long journey since POPIA was adopted by Parliament in 2013. We have reached a number of milestones, as you know. The first sections, or some of the sections of the Act of POPIA, came into operation in 2014. 5 members were appointed, took office on the 1st of December 2016, and it is on this day that we were tasked with this big responsibility of establishing the information regulator from the beginning. It's been, as I say, a long journey, and along that journey, there were many tears, many sweats, many sleepless nights, which are still there, which are still continuing. And of course, there was the second or third major milestone, which was the coming into effect of the remaining sections of POPIA in June last year. And the last milestone, which was July this year, which was the coming into effect of the enforcement powers of the information regulator, and the 30th of June this year, which was us taking over the regulation of PAIA from the South African Human Rights Commission. The journey continues. It is still long, and I think we will hold hands together as we travel this journey together to give effect to the right to privacy in this country, which is one of the most important rights that we have, closely linked with the right to human dignity, and of course, giving effect to the right of access to information to enhance transparency, openness, and responsiveness. Data protection, I think, is one of the most important matters that are confronting us in the 21st century, particularly in the advent of COVID-19, where we all working online, buying online, transacting online, and as we do so, we give our data freely to those who are providing us with the services that we need. But those people have the responsibility to ensure that they use our data responsibly and lawfully in compliance with the law. Without any fear of contradiction, I can say that a data abuse is going to be the second human rights issue, the second most important human rights issue that we have to deal with after climate change. And by saying that, I'm not exaggerating. And with those few words and without wasting time, I will then request Mr. Nemasisi to give us the PAIA overview and the developments. And we're going to be very strict with time because we want to allow as much time as possible for questions and interaction. Mr. Nemasisi, I'm going to give you 15 minutes to do your presentation. Over to you. Thank you very much.
Thank you so much, Chair, and good morning to the members of the Information Regulator and colleagues who are present as well, and the public in general. Chair, my presentation obviously will be the overview of the PAIA as we have taken over this function from the 30th of June 2021. And the presentation topics will deal with the introduction. I'll also deal with the objects of PAIA, the application of PAIA. I'll do the overview, powers, duties, and function of the information regulator insofar as PAIA is concerned. I'll also deal with the issue as to who are the information officer, especially under PAIA, although they are the same with POPIA. I'll deal with the obligation of information officer under PAIA, the grounds of refusal of access, the disclosure in public interest. I'll deal with the complaints to the information regulator, I'll also deal with the investigation power of the information regulator and offenses and penalties. And then in conclusion, I'll deal with the developments. I may start with the introduction, Chair and members. The Constitution of the Republic of South Africa states that South Africa is a sovereign and democratic state that is founded on the advancement of human rights and accountable, responsive, transparent system of government as part of its values. And before South Africa became a constitutional democracy with an enforceable Bill of Rights, the system of government in South Africa, amongst others, resulted in secretive and responsive culture in both public and private bodies, which often led to the abuse of power and human rights violations. It is in this regard, Program Director, that Section 32 of the Bill of Rights in the Constitution provide for the right of access to information held by the state and any information held by another person that is required for the exercise or protection of any rights. In other words, with regard to the access to records held by the private body, you can only request access to those records if you want to exercise or protect any other rights. But with regard to the public body, there is no such requirement. You are required to have access to those rights. So Section 32, 2 of the Constitution in turn provide for the enactment of a national legislation that will give effect to this right by respecting, protecting, promoting, and fulfilling this right. And Promotion of Access to Information Act 2 of 2000, which is PAIA, as amended, is the national legislation which was enacted in accordance with the above mentioned Section 32.2 of the Constitution. PAIA, there was few amendments of PAIA, but the major amendment was the amendment by Section 110 of POPIA, which is the Protection of Personal Information Act, in terms of which the information regulator has taken over the PAIA function, effective from the 30th of June. The other amendment that has been brought to the PAIA is the 2019 amendment, in terms of which a political party is included in a definition of a private body, which effectively means that a leader of a political party or any person duly authorized by that leader is an information officer, or we can call it that person a head of a private body, because a political party is now included in the definition of a private body. So that leader of political party will be an information officer. And the PAIA Amendment Act of 2019 now extend the rights of access to any records of the political party. We are going into the elections very soon, and obviously those rights most people want to exercise those rights to access certain information to those political parties, because they are now included as the private body. So in terms of 2019 Amendments Act, the private funding of a political parties and independent candidates must be recorded, preserved, and made available as prescribed. In other words, the public will have the right to access those records of a political party insofar as their funding is concerned. We now jump into the object of PAIA. What is the object of PAIA? PAIA, its object is to give effect to the constitutional right of access to any information, as I indicated, held by the state or by any held by any other person that is required for exercise the protection of any rights. Its object is also to give effect to the right of access to information, subject to justifiable limitation, and in a way which help balance all other rights contained in the Constitution. So in other words, obviously for you to be able to exercise your other rights in the Constitution, you need to have access to information, because you need information for you to exercise those rights. So that's why the PAIA becomes very critical in order for us to achieve those rights. The object of PAIA is also to promote a human rights culture and social justice for people and the public and private sector. The additional object of PAIA is to establish a voluntary and mandatory mechanism or procedures to give effect to the right of access to information in a manner which enables persons to obtain access to records of public and private bodies as swiftly, inexpensively, effortlessly, as reasonable as possible. And also the additional object of PAIA will be to promote transparency, accountability, effective governance of all institutions. This includes public and private institutions, by empowering people to understand their access to information rights, act on those rights, and scrutinize and engage with the decision-making that affect them. So we jump in the interest of time to deal with the application of PAIA, to whom does this act applies to. So PAIA applies to a record of public and private body, regardless of when those records came into existence. So it doesn't matter whether this record was in existence in the last 3 years. You cannot then say, no, the records have been in existence for more than 3 years, therefore you do not have to have access to those. So it doesn't matter when those records came into existence. PAIA also applies to the exclusion of any provision of other legislation that prohibits or restricts the disclosure of records of public or private body and is materially inconsistent with an object or specific provision of this act. In other words, if there are any legislation that prohibits disclosure of the information, we need to check whether that legislation is consistent with the object of this act. If it's not, therefore, that PAIA will take precedence. And then PAIA does not apply to a record requested for the purpose of criminal or civil proceedings if another law provides for the disclosure of the said records. For example, if you are instituting civil proceedings, you know that in terms of the High Court rules, you can actually request for access to the records that are required for that proceedings. Also, in terms of Criminal Procedure Act, you can access certain access. So if you cannot therefore use PAIA to request access for criminal or civil proceedings because there are legislation that provide for those access. PAIA does not also apply to a record of a cabinet or its committees relating to the judicial function of a court, special tribunal, SIU tribunal, or also judicial officers such as court or special tribunal. It also does not apply to an individual member of parliament or a provincial legislature in that capacity. It also does not apply to a record regarding the nomination, selection, or appointment of a judicial officer or any other person by the Judicial Service Commission in terms of any other law. So we jump now to deal with what are the powers, duties, and function of the information regulator insofar as PAIA is concerned. So the regulator has a very important role in relation to PAIA, and its function include, firstly, promote timely and effective dissemination of accurate information by public and private bodies about their activities. And so that's one of the function of the regulator. The regulator also assists any person wishing to exercise a right contemplated in PAIA where reasonably possible to do so. The regulator also monitors the implementation of PAIA by public and private bodies. So in other words, you will see some official from the information regulator coming to the public or private bodies, checking if their processes are actually in compliance with the PAIA. We also have the power to investigate complaints. I will deal in detail with the investigation power of the regulator. We also have power to act where appropriate as a conciliator in relation to such complaints. So we do also assist in dispute resolution mechanism in terms of those complaints that will have been lodged with the regulator. What are the power of the information regulator? We have power to issue an information notice. This is the notice that will normally be issued during an investigation of a complaint. And in this notice, that's where we're going to request the parties, especially the body that in which the complaint has been lodged against, to provide the regulator with specific information required for purpose of investigation. We also have the power to refer a complaint after conducting an investigation to the enforcement committee, which is an independent body chaired by an independent person, but it is a committee of the information regulator. We also have powers to issue what we call an enforcement notice. This is the notice that will be issued by the regulator upon receipt of the recommendation of the enforcement committee. This notice will be compelling, for example, the body in which the complaint has been lodged against to, for example, to disclose information or to perform certain functions or to act in certain way as will be contained in that enforcement notice. I will deal with the issue of what will be the consequences for non-compliance with that enforcement notice that will be issued by the regulator later on. There are issues about now who are the information officers. So the information officer is actually the head of the body, of the private body as well. So Information officer under PAIA and POPIA are the same people. So the head of a private body or the CEO or the head of a public body, they are both information officer under both PAIA and POPIA. In terms of a public body, or which we normally call them an organ of state, we'll just highlight for national departments, the office of the presidency, the DGs of those national provincial government, the DG of those departments will be the information officers or any person acting in such capacity. And then for provincial departments, the HODs are actually information officers or any person acting in that capacity. Office of the Premier also, the DG will be the information officer or any person acting in that capacity. With regard to the municipality, it will be the municipal manager or any person acting in such capacity as an acting municipal manager. For public institutions like information regulator, ESCOM, the CEO or the person acting in that capacity is the information officer. With regard to the private body, you've got a natural person, which means a natural person who carries on a trade business. Only in that capacity, if you're a sole trader, then you are an information officer for the business that you are conducting. For a political party, as I indicated earlier on, a leader of political party or any person duly authorized by that officer is actually an information officer. For a partnership, any partner of a partnership, so if you have got partnership of 2 or more people, so one of you of that partners is an information officer or any person duly authorized by that partnership. With regard to the juristic person, which means for a company that might be incorporated in terms of the Companies Act, the chief executive officer or a managing director or equivalent officer. The reason why we said equivalent officers is because the structure of a company may be different from one company to the other. In other companies, you don't have CEO, you've got managing director. In other companies, you might find that they call the CEO in a different name, but that person who is the head of that particular juristic person is the information officer. And as I indicated earlier on, the political parties, or juristic person, the CEO or the managing director of those entities can actually authorize any person to be an information officer. But the person who could be authorized as an information officer can only be an employee of that organization. So you cannot outsource to a private company. What are the obligations of the information officer under PAIA? So the information officer must ensure that a manual is developed, monitored, maintained. This is in terms of section 14. 14 is for public bodies, and section 51 is in terms of private bodies. And this manual must be made available on their website, if any. So if a private body does not have, if any body or public or private body does not have a website, they are not compelled to have that manual, to be forced to have a website. It's only for those bodies that have a website, they must put that manual on the website. And also they need to have the manual at the head office of that body for public inspection during normal business hours. They can make that manual available to any person upon request and upon payment of a reasonable amount. Bear in mind that the payment is only upon request for a copy. So if it's for inspection, you don't have, it's no requirement for payment. The manual can also be made available to the information regulator upon request, meaning that the information regulator can request a copy of a manual from any private or public body, and it has to be provided with those manuals. Please note that the manual, in terms of the amendment of PAIA, you do not have to submit your manual to the information regulator unless the regulator requests a copy. So unlike the previous, wherein every public or private bodies that are required to compile manual will submit those manuals to the Human Rights Commission. In terms of the Amendment Act, there is no requirement for you to submit your manual to the regulator unless the regulator requests for a copy. All you need to do is to have a copy available at your head office or upon request or available in your website if you do have a website. The obligation of the information officer as well. So section 14 and 51 of PAIA requires the information officer or head of a body to compile a PAIA manual. This means that each body within a group must have its own manual. One of the questions that we normally receive is what can a group of companies prepare one manual? The Act says each body, the information officer of a body must compile a manual, which means that each body, because they've got different records, each body must have its own manual, and it will specify the records in their manual, what kind of records they have in their manual. Because the information officer of each body, we have got different information of each body, and those information officers, they have an obligation to compile a manual. The information officer as well of a public body must render such reasonable assistance free of charge as is necessary to enable the requester to complete the request for access to information form. So in other words, if a person trying to request access for information, the information officer does have an obligation to assist that person to complete that form for request for access. There are grounds of refusal of access. So in other words, there are certain grounds that has been prescribed in the Act which the public or private bodies may use that for refusal of access. So PAIA provided a list of reasons or grounds of refusal for access to records. There are mandatory grounds of refusal and discretionary ground of refusal of access to records. So mandatory grounds are those that a body is compelled to refuse access, and the discretionary grounds are those that a body may decide to grant or refuse. So they've got a discretion whether to grant or refuse. But with regard to the mandatory one, you are compelled to refuse. For example, if you request personal information of a third party, that it's a mandatory, you are required to refuse access to those personal information of a third party. Please note that a request for access can only be refused on the basis of any of the listed grounds for refusal of access. So in the absence of those grounds of refusal, you cannot refuse access to information unless you are required to disclose that in the public interest. And despite the existence of the ground of refusal of access to records, with the exception of SARS record, the information officer of a body, which means body, a public or private body, is compelled to grant access to a record if, firstly, the disclosure of the record.
Mr. Nebasisi, I'm sorry. You have only 3 minutes to finish because otherwise we're going to run very badly out of time.
Thank you so much, Chair. I'll quickly jump. So let's summarize with regard to the disclosure, the public interest. They ask, irrespective of whether you've got the grounds of refusal of access, in the public interest, you would be required to disclose certain information. We'll quickly deal with the complaints to the information regulator. So a requester or third party may only submit a complaint to the regulator after the requester or third party has exhausted internal appeal. And therefore, but there is no requirement for you that you must, before you go to court, you must go to the information regulator. You can actually, if after you've followed all the process of requesting access to a body, you can actually go to, you can decide whether to go and lodge a complaint with the regulator or you want to go to the court directly. But a complaint to the regulator must be lodged within 180 days. If I may quickly jump to the powers of the information regulator in terms of investigation, we can summon and enforce the appearance of any person before the information regulator. We can also enter and search any premises occupied by public and private bodies. We can search and seizure as well as we conduct our investigation. What are the offenses that we are there in terms of PAIA if there's non-compliance? I'll give an example. Firstly, if you destroy, damage, falsify records, there is a fine or imprisonment for a period of 2 years. Just gonna jump with the quick one, non-compliance with the enforcement notice. If you do not comply with the enforcement notice issued by the regulator, there is actually a fine or imprisonment for a period of 3 years. In conclusion, the development currently, as you are aware, the minister has actually extended the exemption for those private bodies who are not allowed to required to compile a PAIA manual. The exemption is until the end of December. However, from the 1st of January 2022, every private and public body will be required to have the PAIA manual and make them available. So the exemption will not be extended from January 2022. Up until the end of December, you don't, as those private bodies that are exempted, they need to start now to prepare their PAIA manual in preparation for the 1st of January 2022. The regulator is in the process of finalizing the PAIA manual templates for public and private bodies. This template will be publicized to assist those, especially the private bodies that have never compiled manual. It will be a user-friendly template that they'll be able to populate their PAIA manual. And then due to the delay in the publication of PAIA regulations, the regulator may not be able to adjudicate some of the complaints that you may want to lodge with the information regulator. We are waiting for the Minister of Justice to publicize the regulations, and we are hoping that by next week, hopefully, those regulations should be publicized, but we are making follow-up with the Minister because we really need to have those regulations publicized so that the public can start lodging their complaints in the prescribed form. And lastly, the regulator will, before the end of this financial year, will publish the procedure for making information electronically available. So those procedures have already been drafted. They're going through the approval stage, but we will make those available as to how you can make your information electronically available. Thank you so much, Chair. I'll end here.
Sorry, I was muted. Thank you very much, Mr. Nemasisi. I'm sorry for interrupting you. We want to take as many questions as possible. I'm now going to request Ms. Makubela to give us a POPIA overview and developments. Mr. Makubela, please bear in mind that we have time constraints, and I want to make an assumption that the participants who are attending this webinar are aware of the 8 conditions for the lawful processing of personal information. We've been dealing with that for a long time. So if you can just spend time on the developments, that will assist. Over to you, Mr. Nemasisi. Sorry, Mr. Makubela, I'm sorry.
Thank you, Chair. Thank you, Chair. Program Director, Chairperson, members, executives, colleagues, members of the public, good morning. I will delve into enforcement powers. From the 1st of July, 2021, all responsible parties are expected to ensure that all processing of personal information complies with the Protection of Personal Information Act, POPIA. The enforcement powers of the regulator came into effect on this date. As Mr. Nemasisi has also indicated, from the 30th of June 2021, the regulator is responsible for the promotion and enforcement of rights protected by PAIA. This function was previously with the South African Human Rights Commission. Slide 3. On the 1st of February 2022, Section 58.2 of POPIA shall become applicable to the processing of personal information as referred to in terms of Section 57 of POPIA. That would relate to the applications for prior authorization, which means the grace period has been extended until the 1st of February 2022. Slide number 4. The role players in POPIA, you will have the data subject, the responsible party, the operator, competent, and the competent person. The data subject will, means a person to whom information relates. The responsible party can be a public or private body or any other person which alone or in conjunction with others determines the purpose of and means for the processing of personal information. The operator is a person who processes personal information without coming under the direct authority of that party. And the last one is the competent person who is legally competent to represent a child, more especially as you know that children need assistance, for instance, from parents to act on their behalf. If any legal obligation, they must be assisted by a competent person. slide number 4. I won't touch much on this. Chairperson has already indicated that we have previously dealt with the 8 conditions for lawful processing of personal information, which is accountability, processing limitation, purpose specification, further processing limitation, information quality, openness, security safeguard, and the last one is data subject participation. We will then skip this and jump to slide number 9 so that we can deal with of conduct. I mean, the guidelines that have been developed by the regulator. In order to assist responsible parties to comply with POPIA, the regulator's first one is the guidance note on codes of conduct, on the issuing of codes of conduct. This is to assist parties who intend to make applications to the regulator for the issuing of codes of conduct. As contemplated in sections 60 to 68 of those applications must be submitted to the regulator in terms of Form 3 of POPIA regulations. We have been receiving a lot of applications with regard to the issuing of codes of conduct, but what we have observed is that normally they don't comply in terms of ensuring that the necessary form, which is Form 3 of POPIA regulation, is attached to that application. So I'm just emphasizing the fact that when there's an application for the issuing of a code of conduct, applicants must try to ensure that they adhere to the regulations in terms of ensuring that the Form 3 of regulations is attached to the application. The second one is the guidance note on the information officers and deputy information officers. Mr. Nemesis has already touched on that. The third one is the guidance note on prior authorization. I've already indicated that the grace period for making an application to the regulator for the issuing of, for prior authorization has been extended to the 1st of February 2022. But currently there are applications that we are busy processing. We have received more than 300 applications already, but they have been considered. I know there may be a consent from applicants whether, because we may not necessarily have acknowledged receipt on all of those applications that we have received, but yes, they have been processed and the grace period has been extended, as I've already indicated before. And the other guidance note is the guidance note on exemption from conditions for processing of personal information as contemplated in section 36 to 38 of POPIA. The other one is guidance note on processing of special personal information in terms of sections 26 to 33 of POPIA. And the last, information of children. We have already also received applications with regard to the category of such under such applications, and have been considered as well. Slide 10. The regulator also is in the process of finalizing the following guidance notes. Guidance note on direct marketing as provided for in section 69 of POPIA, as well as the guidance note on technical and organizational security measures as provided for in section 19 of POPIA. Information officers and deputy information officers, I think Mr. Nemesis has already touched on this, but what this aspect is that in terms of section 55.2 of officers must take up their duties only after the responsible party has registered them with the regulator. It's a requirement in terms of both PAIA and POPIA to ensure that information officers are registered with the information regulator, as well as it will depend, it's the prerogative of a body to decide whether they want to also designate a deputy information officer or not. So because there is a portal which was developed with the assistance of the Department of Justice previously, and the regulator is aware of those challenges, and currently the portal has been upgraded, editing, updating, and registration of information officers for multiple entities. So an update will be provided on our various communication plans, also looking at the possibility of ensuring that we prepare our own system. So, but a further communication with regard to this will be issued by our communication unit in due course. The duties and responsibilities of information officers. One is the encouragement of compliance with the condition for the lawful processing of personal information, dealing with requests made to the body pursuant to, in relation to investigations conducted pursuant to Chapter 6 in relation to the body. Chapter 6 specifically deals with the processing of which is subject to prior authorizations. You would know that in terms of section 50% application for prior authorization, a determination must be made by the regulator within 4 weeks whether such an application will be or not. So it's in terms of making such a determination, the regulator, if it decides to refer such an application for a detailed investigation, it also has a period of up to 13 weeks to conduct such an investigation. So if there is a need for such an investigation, the regulator will have to work hand in glove with the information officer to assist in terms of carrying such an investigation. So that's what chapters. Another slide 14. In terms of additional responsibilities for information or duties for information officers, that is to ensure that a compliance framework is developed, implemented, monitored, and maintained, as well as to ensure that a personal information impact assessment is done, as well as to ensure that a PAIA manual is developed, as Mr. Nama. Complaints. With regard to complaints, I've indicated in my introduction that the regulator does have enforcement powers as from the 1st of July 2021. So currently, if there is a complaint is to be lodged with the regulator, it must be done in a prescribed form, which is contained in Regulation 5 of POPIA regulations. So it will have to be completed and be submitted to the regulator, such a complaint. That the same form has already if I'm not mistaken, it should be uploaded on our system so that people who may be willing to lodge or submit complaints with the regulator can make use of. A responsible party, for instance, who a responsible
Mr.
party or a
Makubele.
data subject may submit.
Sorry, Mr. Makubele. Mr. Makubele, I think we're running out of time. The slides will be made available. Can you please summarize, because we have lots of questions coming up. Please summarize.
Thank you, Chair. Let me quickly then touch on section slide 18, just to indicate that as parties are now allowed to lodge complaints with the regulator, these are the things that we can do when we receive a complaint. In terms of section 76, that is to conduct investigation or to act as a conciliator, to decide to take no action. We can also conduct a full investigation of the complaint or to refer that to the enforcement committee. Lastly, Chair, Mr. Nemesis has already touched on it's important to, I can talk to slide 23, just to emphasize the fact that we can be imposed by the regulator. Any person who contravenes sections 100 to 106 of POPIA commits an offense. An example may be an obstruction of the regulator, a breach of confidentiality, or failure to comply with an enforcement notice. The contravention of certain sections attracts a heavier sentence. For example, a failure to comply with an enforcement notice attracts a fine or imprisonment for a period not exceeding 10 years, or both a fine and such imprisonment. The last, in conclusion, Chair, POPIA is here to stay, and the regulator has been encouraged to comply with its provisions even before it became fully operational. In addition to the offenses and administrative fines stated above, non-compliance will result for an organization. I will conclude by saying that just to maybe debunk or demystify the misconception with regard to enforcement powers, to emphasize the fact that the enforcement powers are there from the 1st of July 2020, applies to prior authorization as contemplated in section 57 and 58 of POPIA. Thank you, Chairperson.
Thank you, Mr. Makubela. Your sound, I think, was problematic, but I'm hoping that because we're going to be circulating the presentations, that people will then get the gist of the entirety of his presentation in the slides that will be circulated. Can I jump quickly to Professor Snail? Let me also say that I forgot to introduce Ms. Ramusangwana. I don't know if she can unmute her video. Ms. Ramusangwana is our Chief Information Officer responsible for IT. She joined us in June. Ms. Ramusangwana, I see there are lots of questions pertaining to the portal, which we will have to deal with. Can I immediately hand over to Professor Snail and Mr. Dimba to take the Q&A? Thank you.
Thank you very much, Chairperson. Good morning to everyone, and thank you for attending this webinar. there is a wide number of questions, and myself and Mr. Dimba will be facilitating answering these questions. I see here there's a question from the Information Officers Association. Is it reasonable to expect an employee to make requests to an information who is also an employee, possibly a senior manager in the organization? I'm not sure what the question is there. If we can just ask the Information Association to just resend that question. I think there's a mistake. We have here a question from Anton Dreyer. What is the process of amending the, I assume, the registration of the information officer? And can I ask our CIO to kindly answer that question?
Information is
We can't hear you. Your sound.
I would request that
Your sound is very bad. Do something, please. Someone.
can you Chair?
Yes, we can hear you now.
Thank you so much. The responsible party, please send us an email through at registration.ir@justice.gov.za with the reference number that is currently on the registration certificate that was already issued. Thereafter, will make the necessary amendments. Thank you so much.
Yeah, unfortunately, the connection is not awesome. Hopefully, you'll be getting a better connection later. I see there's another question here from Tony Masinge, right? Tony Masinge, is this presentation available for download? We will try and make the presentations available. I see the question from the Information Officer Association has been retyped. Is it reasonable to expect an employee to make requests to an information officer who is also an employee, possibly a senior manager within the organization? May I ask Mr. Namasisi to answer that?
Thank you so much, Prof. That's very tricky question. But if you look at the Constitution, you'll find that it says everyone has the right of access to information. So everyone will include any person can ask if the employee requires that information to exercise or protect their human rights, they have to request that information. The Constitution guarantees the right to everyone, irrespective of whether it's an employer or not. If it's, like I indicated, if it's a private body, obviously you need to indicate what rights are you going to exercise or protect. But if it's a public body, you do not have to disclose the rights that you're going to protect. But that right is given to everyone. Thank you, Prof.
Thank you, Mr. Namasisi. Before I give over to my co-host of the session, I just want to read one of the questions that came from social media. It says, do churches have to comply with PAIA and make a manual available? Mr. Namasisi, I'm happy to answer part of it, to mention that, you know, it would be special personal information and that there are some exceptions in terms of the POPIA, whereby the church and, you know, the employees of the church within the perimeters of the activities of the church, where they would be allowed to deal with special personal information. But with regards to the manual, I'll defer that question to you, Mr. Namasisi, and then over to Mr. Dimba.
Thank you, Prof. Obviously, the question that we need to ask is whether the church falls under the category of those private bodies that might be exempted. If they do not fall under those categories, then obviously they will have to have a manual. And we need to bear in mind to say, if the church creates records, and there might be certain people who may require those records to exercise or protect their rights. So the manual is intended to facilitate accessibility of the records. People should be able to know what kind of records do they have, especially now that there's amendment of POPIA, which include the processing of personal information. The public may want to know whether if that church process their personal information and whether they're going to transfer those personal information outside the country. And those information can only be available through the manual. So, but from the January 2022, as we indicated, every person, whether it's natural, private body, who process obviously or keep records, they would have to have those manual too, so that the public will increase the accessibility of the records. Thank you, Prof.
Thank you, Mr. Namasisi. I do have two questions related to prior authorization for Mr. Makubela. The first one is, can a responsible party continue to process personal information while waiting for the regulator to respond on a prior authorization application? That's the first question. The second one asks, under which circumstances are private entities required to request prior authorization to process personal information? Mr. Makubela.
Thanks, Mr. Dimba. As I've indicated that the grace period has been extended to next year, February. Yes, they can. In the meantime, the personal information. What we normally call prescription, it will start running from the 1st of February 2022. So which means from the 1st of February 2022, once there is an application received, we'll have 4 weeks as the regulator to look at it and determine whether must it be approved or not, or whether it must be referred to a detailed investigation, as I've already indicated.
So the answer is that they can continue.
Currently,
I beg your pardon, Mr. Makubela, your line is very bad. Can someone answer that question, please? Because I think participants are battling to hear him. Can someone take the question on prior authorization?
With that,
because we can't hear him.
Yeah, let me
processing activities. With regard to the second one, deals with what for now, yes, they can continue.
Let's allow Mr. Makubela to sort out his line. Mr. Namasisi, did you want to weigh in on this question?
Yes, I wanted to take in the one regarding what happens when the application is being considered for prior authorization. So section 58.2, it requires the responsible party that notify the regulator that their processing fall under a prior authorization. Immediately when they notify us, in terms, if that section was effective, in other words, if there was no extension of that period to February 2022, those responsible parties would have been required to suspend processing of personal information until the regulator make a determination in the application. Now that the effective date of that section 58.2 has now been moved to the February 2022, they do not have to suspend the processing, so they will continue processing their personal information, but it does not mean that they do not have to comply with the 8 conditions. So they still have to require to comply with the 8 conditions for lawful processing of personal information, but they will process those personal information. The regulator is processing those applications, so they will get an outcome of the applications between now and February 2022. And once they get the outcome, if it's not authorized, it means they will have obviously have to stop the processing because their processing will not have been authorized by the regulator. Thank you.
Thank you, Mr. Masisi. While you hold the floor, we are fielding a lot of questions around designation of information officers. I know that you have, you did refer to this in your earlier presentation, but can we visit that area once more just to be sure? So can a managing agent of an estate be appointed as an information officer? That's the first question. The related question is, do schools also have to appoint and register information officers? And last one related to those two is, can an information officer be an external third party? Just reiterate the points that you made on your presentation. And I'll also ask Ms. Tilly to add on the responses. Thanks, Mr. Masisi.
Thank you, Mr. Dimba. Obviously, the information officers, the schools, they do process personal information of children, specifically, even of parents. Some of the schools, obviously, they need records of the parents. At some schools, they need even our financial records. Where do you stay, your financial records, the names of the parents. So those are personal information that are being processed. And if you look at the definition of who is the responsible party, so school does fall under that definition of a responsible party. So the school need to register their own information officer. In this regard, I have not do the analysis of who is the information officer under school, but I'll assume the principal will be the information officer. I have not, this is not the official announcement of who is the information officer, because we have not done such an assessment as to who will qualify as an information officer. But the head of that school will be the information officer, and they need to be registered with the regulator. This question about the managing agent of a body corporate. This question, it's a very critical question. The managing agent, most of the time you find that it's actually a company that processes personal information. So that company that processes personal information is on its own right a responsible party, and it is required to register its own information officer. But a body corporate can sue on its name, and therefore it does have a chairperson of that body corporate, and they've got managers. So the body corporate must appoint their own information officer, because body corporate does process. An agent is acting on behalf of a body corporate, but it's actually a responsible party on its own name. So the body corporate themselves, they've got an obligation to ensure the protection of the personal information that they process as a body corporate. So there is a distinction between a managing agent as well as the body corporate. So those are the distinctions that we may provide. Thank you.
Thank you, Mr. Masisi. Ms. Tilly, can the chairperson of a body corporate designate somebody else to exercise this responsibility as an information officer?
This is something we've had an extensive discussion about, and you know, the question is perhaps more broadly, as an information officer, as a CEO, can you outsource effectively your role? And I think what we need to be clear about is that you cannot outsource your role to a juristic person. So in other words, if I want to be the chair of a board, or in that situation, it's chair of the body corporate, I can't go to ABC Management Agency Pty Limited and ask them to be the information officer. I can appoint a person to be the information officer, but it's really restricted in that regard, and we have taken legal opinion on this question. So that's the way the legal opinion has put it.
Thank you, Ms. Tilly. Professor Snail, we also got a few questions regarding social media use and how POPIA applies in those instances. Do you want to weigh in on those?
Yeah, I'm just looking at the questions. Yeah.
You want me to read them for you?
Yeah, I was actually reading one from the Information Officers Association. So let me ask this one, and then you can ask that one.
Okay.
It is a personal information impact assessment in terms of regulation 4.1b. Is that a prerequisite to submitting a request for prior authorization? I think I'll ask Mr. Namasisi or Ms. Solal on this one. Colleagues?
I'll take it. I don't think that a personal information impact assessment is a prerequisite to submitting an application for prior authorization. If that is the question, I'm not sure if I got it. If that is the question, please just confirm if it is. That's not a prerequisite. However, preparing a personal information impact assessment would be a preferable tool in trying to ascertain the kind of security or the kind of compliance you have as an entity with POPIA. So I think conducting a personal information impact assessment is a necessary tool, but it's not a prerequisite for a prior authorization application. And so too would be ensuring that you have a compliance framework, because these two tools will assist you in trying to ascertain where you are as an entity relating to compliance. Thanks.
Dimba, you want to ask me that question?
Yes, Prof. The question reads, will I as an individual be in contravention of POPIA if I share if I share personal details of my friend or a person I know on social media or to another person without their permission? Will I be fined or sent to prison? That's the first one. The second one is, do WhatsApp administrators need to comply with POPIA?
Thank you very much. Yes, I think the first question is relatively straightforward. One looks at the definition of personal information. It would include online identifiers, email addresses, telephone numbers, and any other unique identifier that identifies you. So if someone is sharing your personal information on the internet, even prior to POPIA, you would have been able to go to court and possibly get an interdict against that person. So if there is this unlawful, unauthorized sharing taking place, then you would be able to complain with the regulator. Now, regarding the WhatsApp administrators, I think it's not just the WhatsApp administrator that needs to behave. I think it's also the users on the group. There is some information going around about people having to agree to a disclaimer on a WhatsApp group. There are various schools of thought on that. And the regulator is yet to issue a formal position regarding WhatsApp and these so-called WhatsApp disclaimers. So I think I've answered that question.
Thank you, Prof. I would like to give an opportunity to participants on the chat. I see Mr. Lottering has had his hand up for a while now. Mr. Lottering, please feel free to ask your question. You can unmute yourself and then ask. It doesn't appear as Mr. Lottering is struggling to unmute himself while we try and work on that. Do you have more questions, Prof, from the chat?
I wonder,
Yes,
Mr. Dimba, Mr. Dimba and Prof. Snell, if I might just weigh in on the question of WhatsApp and social media. There's a specific issue which is dealt with within POPIA, which is about household processing, and it's dealt with as an exemption. So I think that the people are concerned that they, in their, their home amongst their friends, are sharing information. That's actually dealt with in the legislation and is dealt with as an exemption. So I think, that's really not the intent of the legislation, to deal with that kind of processing. What we're really interested in is big data sets being used, put together, new information effectively being generated about individuals, and then that being used in a way against individuals that's to their detriment. So, if you're sharing a photograph of your cousin on your Facebook page, or you're sending your mother's cell phone number to your sister, that's household processing and falls outside the legislation, and that's something definitely not to worry about.
Thank you, Ms. Tilly. We're going to try again and allow participants to ask questions directly of the panel. I see Ms. Marietta Meyer has had her hand up for a while. Ms. Meyer, would you like to ask your question?
Hello?
You have the floor, Ms. Meyer.
No, sorry, it was a mistake. You can ignore.
Okay, that's perfectly fine.
Okay.
Okay, there is a question from Baba, who is asking, will the regulator hold operators accountable should there be a breach in their environment and the responsible party contracted with the operator to be POPIA compliant? Can anyone from the panel take that one? Will the regulator hold operators accountable should there be a breach in their environment and the responsible party contracted?
Let me take that one, Mr.
With the operator, yeah, please, Prof.
I think since the POPIA is now fully effective in its law, obviously, if there are data breaches, number one, they are now reportable. Number two, if it does seem like there was some form of negligence or non-compliance on the part of the responsible party, the regulator would have to take the matter further and possibly look at fines and other form of redress if there was some form of negligence or non-compliance. I hope that answers that question.
Thank you, Prof. Another question that I would like to put to Ms. Yulal. Ms. Yulal, there's a question asking about recruitment companies. It says, I want to find out if a company or a recruitment agency phones in to confirm information on an ex-employee that is applying for a job, what information are we allowed to give to this company? And the same to a bank or a company where an employee applies for credit. Ms. Yulal?
Yes, Mr. Dimba, can you just repeat that for me, please?
Okay, it says, I want to find out if a company or a recruitment agency phones in to confirm information on an ex-employee that is applying for a job, what information are we allowed to give to this company? And the same to a bank or a company where an employee applies for credit.
I think it's going to depend on, if you're applying for credit, then in all probability you would have signed the necessary consents. And I'm assuming that you'd be able to, and that would be one of the provisos that banks would ensure that there's compliance with. And regarding with applications for jobs, I know that there already are consents that when you apply for a position, you would have to render some form of consent to access your personal information or to verify your referees. That's what I'm aware of. Thanks. But consent is still going to be critical. Thank you.
Thanks, Ms. Hilal. Professor Snail, have you got more on your?
I'm here.
Hmm?
Yes, I'm here.
Do you have more questions on your side?
Yes, I see there's another question here from Lizelle Millard. Just keeping my camera off, my connection's not too great. Lizelle Millard here from Africa Skills Private College with its head office in George. I have emailed on various occasions our company registration form, IO and DIO appointment letters, as well as our manual and privacy policy. Now my question is as follows. As the portal is off, I've emailed all our relevant information. When will you be able to acknowledge receipt of same, and when are you planning to have the portal up again? Please and thank you very much. Can I refer this question to our CIO?
Thank you so much, Prof. We are currently busy processing all the applications that are received via email. We do send acknowledgement once we have processed the application. So soon we will be sending an acknowledgement when we get to that application. In terms of the registration portal, we are in a process of revamping and redefining the registration portal. As you may be aware, there was a lot of technical issues and errors with the portal, so we are trying to address all of this with the revamped system. Once the system is up and running, our communications department will then issue communication on the different communication platforms. Thank you, Prof.
Thank you, CIO. Then we have a question here from Amor. Amor says, I have to agree with Lola Tyndale that the IR consider taking a detailed approach to direct marketing. POPIA is not consent driven, and if the IR stipulates that consent must be obtained afresh, this is clearly not in line or nonsensical email spam that has been going around to opt-out functionality. If consent has been obtained prior to POPIA, consent exists, and surely seeking consent afresh would not be required by legislation. I think before I allow one of my colleagues to answer this one, I think Section 69 is a beautiful piece of legislation. Section 69 talks about prior consent having been obtained, and obviously where you have obtained consent previously and where you are a customer of a responsible party, the POPIA would not require you to seek consent afresh. And yes, I've seen these emails, from suppliers, from very big companies, where they are basically saying, do you now want to opt in again or opt out? I think people were going on the cautious side. When you're not too sure in terms of compliance, what to do, from an attorney's perspective, you will always advise the client that, look, go to the safe side, send out a mail, try and get the consent again. But I fully agree. If you are a present customer, there shouldn't be necessarily another reason to get further consent. I don't know which other colleague would like to weigh in on this matter.
I think maybe I just want to add, Prof. Snail, that if you, yes, definitely if it's an existing customer, you don't need to reacquire consent. But for new customers, consent is required. So you can't circumvent that. Thanks.
Prof?
Yes. I see there's another question here by Anonymous. Anonymous is saying, would capturing of a reference by a job applicant, would that onto an e-recruitment portal, would that constitute a contravention of the POPIA? That's an interesting question, but as interesting as it is, right, usually these electronic recruitment portals, people agree to be part of them. People usually upload their personal information themselves. So it's a very, very thin line. And, you know, I think it's an area that hasn't been explored properly yet. And I think the regulator will have to be tested in terms of, you know, to what extent can e-recruitment companies place your personal information as well as that of referees on their websites. I think it's a new terrain that needs to be explored, and I don't think this platform right now can answer the question in its totality. Mr. Dimba, are there any questions that you're seeing from social media?
Yes, Prof, you mentioned section 69 earlier. There is a question regarding the interpretation of section 69(1) to 69 subsection 4. The question is, interpretation of section 69(1) up to 69(4) of POPIA in relation to direct marketing. Are call centers, that is human to human, are they included in the definition of electronic communication? Would members wish to weigh in on that question?
I did have a look at that question.
I can attempt to do that because it's a question that we are grappling with, because there is a school of thought that says if you receive a call from a call center, that does not constitute electronic communication. And there is another school of thought that says it does. I think we will have to answer this question once and for all when we issue the guidance notes on section 69. That would be my answer for now.
Thank you, Chair. Ms. Tilly?
I wanted to say that I think the question generally with those kinds of calls is how that personal information came to the knowledge of the person who's doing the direct marketing. So I would say that's really been the major concern. But I would agree, yes, I would agree with Chair that that's something we'll have to be more specific about.
But I see a very important question here, which I think we need to deal with. There's been a question here dealing, well, it was a response to Anonymous, but I think I'm going to paraphrase the question. And the question is, does POPIA apply retrospectively? And I think the straightforward answer to that would be no. Number one, we have the theory against retrospectivity, the presumption against retrospectivity. So that's from the legal interpretation perspective. And number two, we also had the grace period. So it would be inconceivable to have the POPIA apply retrospectively. I hope that clarifies that big question that's been asked.
Yeah. Thanks, Prof. There's another question which is a follow-up regarding exemption applications. A participant wants to know how long does it take for the regulator to decide on exemption applications. He or she notes that these exemptions must be published in the Government Gazette, and he notices that there hasn't been any granted up to date. So how long does this process actually take? Mr. Makubele?
Thanks, Mr. Dimba. I'm not sure whether you can hear me now.
We can hear you. Thank you.
Because
Yes, we can.
I'm battling with connectivity. Well, in terms of the timelines, we still need to develop SOPs internally. They have not been developed yet. But with the applications that we have received, they have been processed. And if the applicant is one of those who submitted an application, I think there will be further communication in that regard. We have already acknowledged receipt on all of those applications that we have received. Thanks.
Okay. Here's a question regarding the compliance frameworks. Ms. Sulala, I know you've done a lot of work in this regard. Karine wants to know where they can find a simple example of an impact assessment and also of a compliance framework. Are there plans by the regulator to provide such examples, Ms. Sulala?
I'm not certain if I can say to you that, you know, where you could actually find a good example. The regulator has their internal impact assessment and compliance framework. And I'm not sure if we haven't made a decision as to whether that is going to be published anytime soon. But my suggestion is, you know, there are many other jurisdictions that would have quite notable guidance. If you look at Australia, Canada, the UK, and the EU, they have data. What we call a personal information impact assessment. They have data protection. I think it's a data protection impact assessment. So you would be able to find suitable templates or precedents, so to speak, but you need to make sure that whatever you do, that you're going to be complying with POPIA. And it's well to reference your document with what you see in other jurisdictions, but you need to make sure that there's compliance with the 8 conditions of lawful processing, and that you are able to identify every processing activity that your entity undertakes. If you are able to identify each processing activity, you will be able to also, you know, formulate some sort of a risk assessment in conjunction with each of these processing activities, and ensure also that there's compliance with the 8 conditions of lawful processing. And I think that is the nub of it, in trying to develop your own personal information impact assessment and compliance framework. You have to, and I know it seems like a very laborious process, but it's a fundamental exercise, and all information officers have a statutory obligation to undertake this in terms of Regulation 4. So what you're going to have to do is identify every processing activity, try to identify what are the possible risks, how do you mitigate these risks, and how will you ensure that your entity is going to comply with the 8 conditions in how you process this personal information. I think that's the best advice I can give you. Thank you.
Thank you, Ms. Sulala. You make a very important point that even though it's quite laborious to do this, but it's part and parcel of your risk management strategy within an organization. Anyway, it's something that needs to be done. Prof.
Yeah, sorry, you're still finishing to say something.
No, go on.
I see a follow-up question to direct marketing, and I find this question most amusing. It's from Anonymous, and the question is, with regards to direct marketing, would educational marketing training, material and video links for training, I would assume for training of POPIA, or certain products relating to POPIA, whether that would be considered as direct marketing? Well, I have some good news and some bad news for my colleagues who have been engaging in these practices to educate people. Unfortunately, it would then fall under the perimeter of marketing. So you would expose yourself to a complaint should you be marketing to people who are not your clients. I just find it funny because prior to the 1st of July, everyone was selling compliance and webinars regarding, compliance, get compliant. So yeah, it's some interesting times. Even those who are selling education will have to comply as well. I hope the comment is taken tongue in cheek.
Prof, I just want to add something to what you said. There was a question that I picked up on the group on accreditation of certain bodies. And I just want to state that the regulator is not empowered and POPIA doesn't accredit anybody. So any bodies that are claiming to be accredited, they are not accredited. I mean, they're not accredited by us. The legislation doesn't create any accreditation responsibilities. So people need to be very wary of these so-called accredited bodies out there. I don't know if any of the members want to add to that. Thanks.
I'd like to weigh in on that, Mr. Locke. I think you correctly said so. Our act does not authorize the regulator or anyone to pass themselves off as a certifying organization or some organization that will give you some form of documentation to say that you are compliant. It is unfortunate that there are some colleagues out there that are engaging in these unsavory practices. But with that having been said, if someone does want some form of formal training, there are very reputable higher education institutions in our country, as well as international organizations that provide training in the area of data protection. And I can only advise that people follow the reputable, accepted channels of training when it comes to qualifications that one may want to have. I'm not saying that other service providers cannot give insightful training and so forth, but those who always say they certify compliance, the light should go off. There's something not right
there. Thank you, Prof. Just one more question related to PAIA manual templates. Mr. Namasisi, could you please repeat your point regarding the templates, whether they are available? Somebody would like to have a look at a manual template so that they make sure that they've covered all the requirement.
The template has been developed. It's going through the approval process internally. They will be published as soon as possible. They are not readily available now, but they have been drafted already. They're just waiting, going through the approval process internally. And they will be published as soon as they're approved. Thanks.
Thanks, Mr. Namasisi. Prof, that's all I had on my board. Over to you.
Yeah, I see there's still one or two questions that we can attend to. I'm also mindful of the time that we have now. I see we are now exactly at 12:33, so we can grab two more questions, and then I thought maybe we could allow the chairperson to say one or two last words before Ms. Tilly gives a vote of thanks, right? I see here a question, and this is a lot. It's from Al Pasha. To whom does the POPIA Act apply? Does it also apply to small investment companies as well that do not process data? I'll start answering this, and if someone wants to add, you should. I think it is extremely unlikely as an investment company that you would not be processing personal information. In fact, you are most likely going to be processing special personal information, most likely as well as financial information. And yes, the POPIA applies to any body, not just any body as a human being, but a body, be it a juristic person, be it a government body, be it an association, be it a partnership, basically anything that we could recognize in law as having a legal personality. We always get the interesting question about trusts. Do trusts also have to comply? So yes, the POPIA applies to everybody. I hope that answers that, Al Pasha. Then, okay, I'm going to skip this one. The question was, how long does it take to register? I think we've dealt with this. Then we have, yeah, I see some of the questions were answered here. I see that there's a body corporate question. Let me just go to the bottom here and see if there's anything from social. Okay, there's the question about trusts. Looks like on the Q&A we've exhausted that. I just want to see if there's anything on the social media link. Okay, there's one question here from social media. In relation to private investigations, for example, detecting counterfeit goods, does the Act exclude such activities or is pre-authorization required? I'm going to set the stage for that question. I think it's a collision between Section 6 and Section 57, and I will allow one of my colleagues to take the matter further, either Mr. Nemasisi or Ms. Solar, one of the two.
Sorry, Prof, I didn't get that question. Can you please repeat that?
Yes, the question was here, Solar, in relation to private investigations, in other words, detecting counterfeit goods and so forth, does the Act exclude POPIA for such activities, or is pre-authorization required? So my initial jab before I hand it to you is, it looks as if it's a collision between Section 6 and Section 57. Over to you.
Look, sorry, I've been having a challenge unmuting. I think if we're going to look at Section 6, because with Section 6, it deals with the exclusions, where the exclusions would not apply to processing of personal information if by or on behalf of a public body, if it's going to be dealing with national security or the prevention, detection, and in the identification of unlawful activities. So I think in that regard, but it's a difficult one to answer. But my gut feeling says to me that the exclusion in terms of Section 6 would be applicable. I don't know if anyone else wants to add to that.
The exclusion is applicable when you are a public body or acting on behalf of public body. So not everybody who will come and say, I'm conducting an investigation to detect crime. When you are not a public body or acting on behalf of public body, will just go and do that. Others will be abuse of those powers. And that's why it's specifically for public body. So if you are doing that on behalf of public body, you would be, obviously the exclusion might be applicable. But if you are doing it for private purposes, just say you're conducting an investigation, you can imagine how many people may use that as abusing their power when that process that they're doing is not legislated in any way. So that's the issue that we need to look at to say, are you doing it for public, on behalf of public body, or are you a public body conducting that kind of investigation? But if you are not, then you do not fall under the category of the exclusion that we see in Section 6 of POPIA, especially if you look at 6(1)(c), because it says by or on behalf of a public body. So that's where you will be able to get the authority, whether you are actually, your investigation is actually done for or on behalf of public body. Thanks.
Yeah, I think that's a comprehensive answer. And I think Mr. Dimba and I should thank the questions that have come from the participants, in line with the chairperson's request that we respect time and adhere to time. I would like to give over to Ms. Tilly to give her vote of thanks in the event that Chair doesn't want to say anything further. Thank you.
Prof, just one word, please, before we hand over to Ms. Tilly and the Chair. There's a question regarding an external company that complies with the GDPR. The response there is, if you are an external company with a presence in South Africa, probably processing personal information of data subjects who are in South Africa, you still need to comply with various provisions of POPIA. The good thing is that POPIA and the GDPR maintain a similar level of standards in terms of protection of personal information. So there isn't a whole lot more that you would need to do if you're already used to GDPR, but you would still need to follow the various provisions in terms of implementation of POPIA and the implementation of the law. You would still need to satisfy those provisions. It's just that if you are used to GDPR, it will be an easier process for you. Thanks, Prof. Over to you, Ms. Tilly, and the chair.
Thank you. Chair, I don't know if you have any closing comments for us.
No, if you can just talk about the questions that we have not asked, because there are quite a number, and see how we're going to deal with that.
Sure. Thank you for that. I think there are a number of issues that have come up during this webinar that I think we will go away and think about. One of the questions that was raised was whether or not we could run a webinar for information officers specifically. And I think there is certainly a plan on our part to look at information officers of public bodies. They have a specific reporting responsibility to the regulator now, and that's something that we would like to talk to them about. But so without having made a decision, I think I can say that we would like to certainly do webinars that focus on particular role players' responsibilities. The regulator plans to, as we've been doing, to continue this webinar series. Certainly with the legislation coming in now, there are a lot of questions. At this point, we may not need to have them as regularly, in time to come, but we certainly plan to keep doing these, as well as trying to respond to questions and comments on social media, or as organizations reach out to us. I think I've made a particular note of the query around plain language information for people who want to do an impact assessment. I think that's something we can certainly think about. Training is part of the regulator's mandate, and so that's something that again we'll certainly be trying to do in the most effective way possible. So where we're able to do training online, or alternatively training for organizations who would then be able to go out and train perhaps their members, that's certainly going to be something that we would rather focus on, perhaps, rather than one individual small organization. That being said, I would like to thank my colleagues for their preparation for the session. I think you can see that Mr. Nevisisi and Mr. Makubela have gone to some trouble to make sure that they try to lay out the framework that we're looking at. And thank you to Mr. Dimba and Prof. Snell for managing the questions as they come flying in. And Ms. Zondi, thank you for organizing this webinar with your team. And thank you to Chair and the other members of the regulator who've been present. We look forward to engaging with you again. We do take your comments and questions seriously, and we will try to deal with them in as systematic a way as we can. I think we're particularly keenly aware of the need for the portal to work, and that's something that we really are taking seriously and prioritizing as a concern. Prof. Snell, have I covered the areas? Is there anything you'd like to add?
Yes, I think you've covered everyone. I think you've given all the thanks to everyone. And I think within the last seconds, I see it's 12:44. I think I should thank you as well for your insight and for also giving a vote of thanks to everyone. I think we've exhausted time allocated.
In which case, thank you very much, and let me call this webinar adjourned. Thank you very much, everybody.
Thank you, Alison.